Welcome to my world. Come on in and make yourselves at home. Welcome to my life. I know everything's gonna be all right. Welcome to my world. Oh, won't you come on in? Welcome to my life. It's known as the Tiger's Den. Greetings to all of my subscribers. I want to thank you for being with me for as long as you have, and the new subscribers that's coming on in. We want to say greetings and thank you for your time. This is from Toothless and the moderators. Welcome to the Tiger's Den. And I don't see it. Can you hear me now? Hopefully you can. I don't see my mic and my camera down at the bottom. And I don't know why. Okay, I see it now. I need to pull it up a little bit. Welcome to whoever is in the chat. Moonchild Pink, welcome. All that are in the bushes, all that are in the trees, all that's on the beach, all that's in Aruba, all that's in Belize, all that's wherever you are, welcome. Hello, Regina M. Glad to see you. The last time we were together, I believe it was Charlene who gave us some information about some things that was happening with Fani Willis, Fani as she goes. And so I looked into that information, and we're going to talk about that a little. But of course, as we start out with our plea bargains. And the last time we were together, I was telling you all some statistics, but I didn't show you guys the figures. So we're going to start off with the figures, and then I'm going to read the next section, and then we'll get into Fani Willis and the YSL case, because it was really terrible today. It was just really, it's almost unbearable to watch this stuff in prime time, to see this really happening, and we're being censored so in what we can say and can't say. It's kind of like a modern day lynching, really, is what it's like. You know, it's the odd thing about it is it could have been these people all along. It's people that look just like us that's doing it, and it's just horrible, and it feels bad just to see all of the things that are happening in the courtroom. And we know that our communities are really, really bad. We really do know that. And that's all over the United States. But we know why they're bad. It's systemic and it's designed. And then we're given the tools to destroy and not build. So we can kind of understand that. But when you look at the totality of this, a lot of those young guys were strung out on drugs. And it's just unbelievable. They have mental diagnoses, and this was probably before they even got to the drugs, and they're being treated like people with common sense that would do common things, and that's not happening here. I'm not excusing anybody's behavior, and we all have to take responsibility for our actions, but there are reasons that things happen, and we have to look at it, as I stated, in its totality. What I want to start off with is showing you the figures of the sentencing to show, the treatment in sentences, going to court, as it relates to not going to court and accepting a plea. So let me get started with that. It's interesting and it's pretty easy to read. The sentence years, primary offense, plea versus trial. So the burgundy is the trial sentence years, and the blue is the plea bargain years that you're offered on average. Trial sentence years is 10 years, 8 months. Or I guess you could say percentage-wise, average on the plea bargain is 3.3. Administration of justice, 3.2, 1.2 on the plea bargain. Antitrust violations, you go to trial, 12.1, plea bargain, 1.4. And they relatively do theirs when they, say them out loud, they say them in months, but these appear to be years. Arson, 14.8, 5.0. Now, if that's the same crime, what's the difference that you would get such a difference in the sentencing, other than the fact that they're taking away our Sixth Amendment right? And that's the only thing that you can see. Take a chance, you take a chance. Assaults, 5.2. Plea bargain, 2.1. Auto theft, 15.5. Plea bargain, 6.3. Bribery, 4.1. Plea bargain, 2.1. Burglary, breaking and entering, 12.5. Plea bargain, 1.6. And we see the title of that one. We can't hardly even mention that one. 16.9, 12.5. Civil rights offenses, 4.9, 2.1. Drug communication facilities, it has here 0 and then 2.3. Drugs simple possession, 0.2, 0.3. So I don't know if these numbers are months or years or percentages. I tried to help them out, but hopefully it'll tell us at the bottom. Okay. Years. It's years. They're the years at the bottom. Drugs, trafficking, manufacturing, and importing, 14.5, 5.2 if you plea bargain. Embezzlement, 4.7, 0.6. Environmental, game, fish, and wildlife offenses, 1.3 and 0.2. Okay. Figure 1, sentence years and primary offense in plea trial. Firearms includes use, possession, and trafficking, 17.6, 5.8. Food and drug offenses, 4.0. Plea bargain, 0.4. Forgery, counterfeiting, 1.2. 1.2. Either way it goes, it looks. Fraud 6.0, plea bargain 1.9, gambling lottery 0.8, 0.2 if you plea, immigration 2.8, 1.1. If you take anyone hostage, 25.0, 15.9 if you plea, larceny 3.1, 0.7 if you plea, manslaughter 14.4, 5.6, money laundering 5.1, 2.1. If you unalive someone, 30.7, 17.5 if you plea. National defense offenses, 6.6, 4.8. Prison offenses, 2.2, 1.0. Racketeering and extortion, 8.9, 5.4 if you plea. Robbery, 12.3, 6.0. SA, 19.0, 9.3. Tax offenses, 3.2 if you please, 0.8. Traffic violations and other offenses, 6.0 and 1.1. Those were the ones that I did not show you guys the other night when we were talking about the plea bargain. And now we're at plea bargaining and coercive prosecutorial discretion. Today, the Federal Rules of Criminal Procedure explicitly recognize and sanction plea bargaining. In exchange for a defendant's agreement to plead guilty, prosecutors may offer to not bring certain charges or to dismiss certain charges. They may agree to recommend or not to oppose a particular sentence or sentencing range. In addition, they may agree to argue for or against the application of particular sentencing factors. The flip side of all of these options is that prosecutors may also threaten to add charges or to recommend increased sentences if defendants refuse to plead guilty. That's the scary part. In one of its early opinions favoring plea bargaining, the Supreme Court expressed a concern that failing to constitutionally approve the practice would drive it back into the shadows from which it had so recently emerged. The problem is, since that time, plea bargaining has largely remained in the shadows. Judicial scrutiny of guilty pleas is extremely limited. Unlike in some states, judges at the federal level are prohibited from participating in the plea bargaining process. Although they are required to determine that a guilty plea is voluntary before accepting it, voluntariness is all but presumed as long as the judge has reminded a defendant of his or her right to a trial and recited rote language listings the protections of a trial affords. As one federal judge has acknowledged, most judges happy for their own reasons to avoid a time-consuming trial will barely question the defendant beyond the bare bones of his assertion of guilt, relying instead on the prosecutor's statement, untested by any cross-examination of what the underlying facts are. Because plea negotiations take place outside the purview of the court, both the judiciary and the public are cut off from exercising any oversight. The result is that prosecutors possess nearly unchecked discretion in plea negotiations, and that's scary. An imbalance of negotiating power. In theory, plea bargaining is a negotiation between the government and the defendant, but the two sides do not come to the bargaining table as equal adversaries. The prosecutor is almost always at an informational advantage because he is not required to share information from his investigation with the defendant before offering and requiring the acceptance of a plea deal, leaving the defendant to guess what the prosecutor will be able to prove beyond a reasonable doubt. In addition, as discussed in greater depth in the following sections, many provisions built into the fabric of the sentencing system strengthen the prosecutor's bargaining leverage. In fact, because certain key sentencing benefits are only available to defendants who plead quickly, there is even greater pressure to secure a plea agreement before the defendant or defense counsel have had any opportunity to evaluate the merits of the prosecution's case. Specific bargaining tactics. Charge bargaining. Sentences are highly influenced by the specific crimes that are charged, a decision that is entirely within the discretion of the prosecution. Because any number of criminal statutes might apply to a defendant's conduct, there is usually a wide array of charges from which the prosecutor can choose. Thus, prosecutors may threaten to charge under the statute carrying the highest maximum penalty in order to obtain bargaining leverage. They may also intimidate defendants by threatening charges that carry mandatory minimum penalties. There is no legal basis for a defendant to challenge the sufficiency of a grand jury indictment in federal court, and a grand jury may indict on mere hearsay without ever hearing evidence favorable to the accused. So prosecutors retain the upper hand to threaten more serious charges, even if they are supported by evidence that would be inadmissible at trial, can be defeated by countervailing evidence, or are wholly unsupported by the law. Because so few defendants are willing to risk going to trial, prosecutors' charging decisions are largely free from judicial scrutiny. That's a sin and a shame right there. If it doesn't do anything else, it should deter one from purposely breaking the law. If it does nothing else, it should do that. I think I just read this. No, I don't. I thought I did. It's hard when these things don't want to go right. Specific bargaining tactics. Sentences are highly influenced by the specific crimes that are charged, a decision that is entirely within the discretion of the prosecution. Because any number of criminal statutes might apply. I did just read that. I'm down at the bottom here. Charge bargaining strategies enable the prosecutor to exert considerable pressure over defendants to plead guilty. Professor Lucian Dervin recently highlighted a case that starkly illustrates the power prosecutors have over sentences because of their unbridled discretion to select charges. Lee Fastow was the wife of Enron's former chief financial officer, Andrew Fastow. Initially, prosecutors charged her with 6 felony conspiracy and tax fraud counts, which under the sentencing guidelines carried a potential sentence of 8 to 10 years in prison. Under a plea agreement, the prosecution agreed to seek a sentence of only 5 months. 8 to 10 years to 5 months. When the presiding judge rejected the plea agreement, given that probation officers had recommended a sentence of 10 to 16 months, Ms. Fastow changed her plea to not guilty. To maintain her cooperation and the cooperation of her husband, who was also facing prosecution on separate charges, prosecutors then withdrew the original charges and reached an agreement with Ms. Fastow for her to plead guilty. The revised plea agreement involved a misdemeanor tax charge carrying a potential sentence of 10 to 16 months under the guidelines. Both sides requested a sentence of 10 months, and the court imposed a sentence of 12 months. At the second plea hearing, the court commented, "The Department of Justice behavior might be seen as a blatant manipulation of the federal justice system and is of great concern to this court. Such manipulation is indeed troubling, but it is all too common. The consequences for those who insist on their right to a trial are even more severe because many prosecutors believe that once they have made a threat, they cannot hesitate to follow through, no matter how outrageous the threat is. Otherwise, their threats will not be taken seriously in the future, and they will undermine their bargaining leverage." So they just playing a game with people, it sounds like. Fact bargaining. Apart from selecting charges, prosecutors can also influence sentences by bargaining with defendants regarding what facts will be considered when determining their sentences. In considering the facts relevant to sentencing, judges rely on the probation officer's pre-sentence report, PSR. The probation officer is supposed to conduct an independent investigation into the defendant's conduct and criminal background. But in reality, the description of the offense in the PSR is usually derived from information provided by the prosecutor in the indictment. When a defendant pleads guilty, he typically reaches an agreement with the prosecution regarding the relevant facts, and that stipulation is expressly set forth in the plea agreement. Judges may also take such stipulations into account at sentencing. In fact, when the statement of facts included in the plea agreement differs from that included in the PSR, courts tend to defer to the plea agreement. So the factual details that will be used to evaluate the defendant's sentence under the guidelines is yet another item for the prosecutor to trade, and the incentive for a defendant to reach agreement with the prosecutor becomes even greater. Although the Department of Justice has consistently instructed prosecutors to only stipulate to facts they know to be true and to disclose to the court all facts relevant to guidelines calculations, fact bargaining persists. When no defendants in a criminal conspiracy exercise their right to a trial, as is almost always the case, there is likely no way to know that fact bargaining has occurred. So, by continuing to take advantage of their discretion to force pleas, prosecutors can prevent their own manipulation from being uncovered. And this is supposed to be integrity and honor and justice for all. And then they have this picture here of a trial. FedEx, UPS, and the trial penalty. In 2013, the federal government excused both FedEx and UPS of illegally conspiring to distribute controlled substance by delivering packages containing pharmaceuticals purchased from internet pharmacies. Neither company was actually aware of what was in the packages. Despite the novel theory of the government's case, UPS quickly entered a non-prosecution agreement and succumbed to a fine of approximately $40 million and a slew of corporate governance reforms. By contrast, when FedEx opted to take its case to trial, the government sought fines of $1.6 billion, 40 times the amount it was willing to accept from UPS in exchange for the non-prosecution agreement. FedEx ultimately prevailed after the presiding judge expressed skepticism of the case and the government dropped its charges. While the trial judge declared that FedEx was factually innocent of the charges, the only reason the judge even got involved was because FedEx insisted on challenging the charges at trial. UPS has engaged in the same conduct and was equally innocent, but incurred a $40 million fine because it gave up its right to a trial in exchange for leniency. So if they do it to corporations, we little people don't stand a chance. Many prosecutors will not prosecute to use the full extent of the bargaining power to secure guilty pleas, draconian plea agreements, and rights bargaining. In addition to charge and fact bargaining, prosecutors also have wide discretion to dictate the terms and timing of plea agreements, and they can insist on objectionable terms knowing that those terms will likely never be scrutinized. For instance, in many districts, it is common practice to require defendants to waive the right to appeal their sentence or important legal rulings, including, for example, the legality of the criminal statutes or police conduct, including the legality of a stop, search, or seizure, or the acquisition of other forms of evidence. And where a defendant has already litigated such an issue, waiver of the right to appeal and adverse determination is frequently a condition of the guilty plea. Increasingly, prosecutors are requiring defendants to waive their right to receive exculpatory evidence in the possession of the government. Very few defendants will refuse to accede to such terms because the only other choice is to take the case to trial and face a much higher sentence. So prosecutors can make plea offers on an all or nothing basis, confident that defendants will accept any terms to avoid an excessive sentence and that judges will rubber stamp the deal because they do not want to deny a defendant the benefit of a bargain for a lower sentence. With fewer and fewer defendants opting for trial, judicial scrutiny of the terms of plea agreements is increasingly limited, as is judicial scrutiny of police conduct, because defendants are coerced into waiving the right to challenge misconduct before the trial court or on appeal. In the rare case where a defendant goes to trial and challenges the prosecutor's draconian terms, the prosecutor will likely object to the court invading its domain. For example, in one federal case, the defendant was offered a plea agreement that would preclude him from making arguments at sentencing comparing his culpability to one of his co-defendants, a comparison which the law requires of the sentencing judge. The prosecutor was only willing to remove the term from the plea agreement if the defendant first agreed to plead to additional counts that would ultimately result in exposure to a lengthier maximum sentence. When the defendant attempted to raise the unfair plea agreement terms to the court's attention, the prosecutor berated him, arguing that if he wants to enter into a contract with the government, his choices are perforce constrained by what the government is prepared to agree to. Perhaps the most extreme example of draconian plea terms was only recently limited by action of former Attorney General Eric Holder. In many districts, prosecutors were seeking a waiver of a prospective claim of ineffectively assistance of counsel as a condition of a guilty plea. In other words, to avoid the trial penalty, an accused would have to agree that she would never challenge the fact that the plea itself was the result of ineffective representation of the very counsel who assisted the defendant in understanding the strength of the case and in the vast majority of cases recommended the guilty plea. NACDL and various state entities determined that this practice was unethical, and after a challenge to a rule prescribing this kind of waiver was rejected by the Supreme Court of Kentucky, the Department of Justice barred the conduct. But the capacity of prosecutors to construct ever more onerous condition for a guilty plea cannot be overstated. Indeed, federal prosecutors now seek even the waiver of rights under the Freedom of Information Act. I'm going to read this little case here, and we'll call it a night for the plea bargains. David Anthony Taylor and the trial penalty. David Anthony Taylor was a member of a gang in Southwest Virginia that was implicated in a sting of 10 robberies in 2012. The gang targeted drug dealers because they would typically have drug proceeds in their homes and would be reluctant to report the crimes to the authorities for fear of arrest themselves. George Fitzgerald, the leader of the gang, conducted the surveillance of the victims, decided who would participate in each home invasion, and divided up the proceeds afterwards. He also took a cut of the proceeds from all 10 robberies. Taylor, on the other hand, was the low-level member who participated in only 3 of the 10 break-ins. He was not involved in planning any of them. Fitzgerald described that Taylor's role was to act as a human shield. As the first member of the gang to enter the house, he was the one most likely to be shot if the victims were armed. When the gang members were indicted, all of them except Taylor pled guilty. Fitzgerald, the ringleader, was sentenced to 22 years in jail. After receiving a reduction for cooperating with the government against the other gang members, the other low-level members received sentences between 7 and 14 years. The prosecutor initially offered Taylor a plea deal. It would agree to indict him for only 1 count of robbery and 1 count of brandishing a gun. But if Taylor refused the deal, the prosecutor threatened to file additional charges. Taylor chose to exercise his right to a trial, and the prosecutor made good on his threat. He filed a superseding indictment, adding 2 more counts, including an additional gun charge, which stacked another mandatory 25 years onto Taylor's potential sentence. Taylor's first trial resulted in a hung jury, but the second jury convicted him of 3 of the 4 counts in the superseding indictment. He was acquitted of 1 of the gun charges. Although the prosecutor had moved at trial to exclude evidence regarding Taylor's potential sentence from being presented to the jury, because it might confuse them, after conviction, he sought a 42-year sentence, an upward variance from the guidelines. In support of that onerous I think that's onerous. Onerous penalty. The prosecutor argued that he could have charged Taylor with participation in another separate robbery and that the guidelines did not appropriately account for Taylor's failure to accept responsibility for his crimes. Taylor was ultimately sentenced to 28 years in jail, longer than any of his co-defendants, even the ringleader. So this is how they do it, and they get by with it every time. It's really sad. So we start back up in let me see. Let me go ahead and just read this page, and we'll start back up at that page 31. So I'm going to just go ahead and finish this page 30. Prosecutorial attitudes and incentives to coerce. One criticism of constitutional jurisprudence on plea bargaining is that it fails to acknowledge that prosecutors, as officials of the state, have obligations beyond their own personal interests. In our adversarial system, prosecutors face strong personal, professional, and institutional incentives to secure pleas. Prosecutors, however, are ethically obliged to do justice and not win at any cost. Prosecutors are required to act as an arm of justice and not merely as an adversary to the defendant. Unfortunately, many prosecutors will not hesitate to use the full extent of their bargaining power to secure guilty pleas. While most prosecutors will not acknowledge that defendants should be punished for going to trial, most adopt the attitude that leniency is only for those defendants who admit their guilt before trial, which, of course, amounts to the same thing. If a prosecutor finds himself in a difficult position of having to support a much harsher sentence than he was originally willing to accept in exchange for a guilty plea, the most common refrain is that he is merely applying the law. That is a hard argument to swallow. However, because prosecutors actively advocate for amendments to the law to increase their bargaining power, the Department of Justice frequently pushes Congress and the Sentencing Commission for higher and higher penalties, further evidence of a strong desire to enhance their negotiating leverage. May that never be, but it seems like it's happening daily. Inadequate constitutional protections for defendants during plea bargaining. In 2012, the Supreme Court finally acknowledged that plea bargaining had replaced trials as the nearly universal means of resolving criminal cases. It is not some adjunct to the criminal justice system. It is the criminal justice system, because the ultimate fate of defendants is now almost always decided before trial. The court's landmark decision in Missouri v. Fry and LaFleur v. Cooper recognized that defendants are entitled to effective assistance of counsel during plea negotiations. But while this is certainly a welcome concession, it does not remedy the imbalance of power between prosecutors and defendants. Defendants who are represented by effective counsel are still up against the prosecution's unrestrained charging discretion and informational advantages. And, as discussed in more detail below, the exorbitant sentencing guidelines and statutes skew the playing field even more in the prosecutor's favor. And then we'll call it quits there. And what's so sad about this is we are affected by this more than anybody in the world, this system. and we care the least about finding out how and what is happening to us and how we can change what's happening to us. Well, greetings, Phyllis. Glad you made it. And hello, Charlene. Glad you made it. So that is the part that's really sad, because what's happening in this Young Thug case, this lady got all of these guys who have committed separate crimes throughout their life, and most have gone to prison, and some were just coming home. And she scooped them up in the name of RICO, going back to the time that they committed their crime and just finished serving time. And then they gave them plea deals. And they gave them all plea deals. And now they're calling them all as witnesses, and they're impeaching them with their own statements that they gave in their interrogations and what they signed in the plea agreement. And that's just, to me, double jeopardy. But we'll talk about that once we finish talking about this DA, Fani Willis. It's amazing, Miss Willis' actions. And, everything is alleged until you're proven guilty in the court of law. But this started happening actually in 2013 is when she started being looked at. Now, this is a post on IG, and his post is by Owen Gregorian, and he says pretty much the same thing as this other article that I'm going to share with you guys. Because they also have a video. So it's called The Gateway Pundit. This is some very interesting stuff. If it's true, it's some very, very interesting stuff, and it looked to be true. But they filed a complaint against her. This article, they started out in 2023, and this is an article that came 2024, February the 10th. And so, Charlene, I thank you for sharing this with us, because the voters, who this is really important to, the voters of Georgia, really, I hope that people are really doing the best that they can to encourage them to really see what's going on, and that this lady, who they may think is their hope, is really not their hope. And so let's go with this. It's really interesting, I thought. Over half of Fani Willis' campaign contributions are allegedly tied to illegal money laundering. New complaint claims. So follow with me, y'all. And we do know, as a disclaimer, everybody is presumed innocent until proven guilty in a court of law. I guess unless they plea bargain. Here we go. Soros-funded Fulton County District Attorney Fani Willis is now at the center of a scandal involving her campaign finances. A new complaint filed alleges that nearly half of Willis' campaign contributions, amounting to approximately $168,000, are linked to illegal activity, including money laundering and identity theft. The Gateway pundit first reported Fani Willis' money laundering network back in September 2023. And believe it or not, I do have that article. Thank you, Regina. That article was September the 3rd, 2023, 7:30 a.m. And the guest post was by Chris Gleason. In a shocking turn of events, a bombshell investigation has uncovered jaw-dropping connections between Fani Willis and a sprawling web of election fraud and money laundering activities. Fani Willis' involvement will be sure to send shockwaves through the political landscape. The investigation, which spans across multiple states and multiple jurisdictions, have revealed a complex network of illicit operations aimed at undermining the very foundation of our constitutional republic and the rule of law. Sources close to the matter suggest that Willis was a massive beneficiary in the federal and Georgia RICO enterprises. It appears that she is currently playing a key role in orchestrating a systemic scheme to manipulate election outcomes, casting doubt on the integrity of the entire electoral process. In the lead up to the 2022 midterm elections, my team uncovered a massive money laundering network of campaign finance contributions being made via Act Blue. And Act Blue is what the Democrats use for you to donate. I've used Act Blue, so I know what Act Blue is. I've donated mainly when Barack Obama was in office, for sure, and was running for office. But boy, listen to this, because this really is going to knock your socks off. Real or imagined, this is really something, and these people put in a lot of work, so you just take it how it comes. One of the top beneficiaries of this money laundering RICO enterprise was none other than Georgia Senator Raphael Warnock. The Gateway Pundit was the first news organization to cover the massive money laundering network that financed the Raphael Warnock campaign. As our investigation progressed, we expanded our efforts into other states, such as Missouri, Maryland, Wisconsin, Arizona, and then into every single state. Working with the Epoch Times investigative journalist Stephen Kovac, we made a stunning find. Many of the top Act Blue contributors never made the individual contributions. Many of these not employed contributors were the victims of a highly sophisticated money laundering scheme. The scheme was further exposed when I provided the data to James O'Keefe and his people at O'Keefe Media Group, who captured many unwitting money laundering smurfs in Maryland. And they're going to explain to you what a smurf is, but this is really amazing how the majority of the people that gave to Fani Willis and these other people don't even live in their district. And what are the chances that you would get all of your donations from Europeans in other states that don't give that way to their candidates? It's kind of amazing. This is really something, y'all. This massive ongoing money laundering operation involves wire fraud, evasion of campaign finance limits, structuring of financial transactions, tax fraud, nonprofit fraud, identity theft, and elder abuse. The RICO operation is still in operation today, using the identities of unwitting elderly and other Democrat voters. This massive RICO money laundering enterprise is the fuel for the entire election fraud RICO operation. Buying a district attorney. The criminal money laundering enterprise operates at the federal, state, and local levels. The first local elected official identified as part of the ongoing money laundering operation was Alvin Bragg. And we know he's one of the guys that is, trying to take down Trump. Alvin Bragg received massive numbers of campaign finance contributions from the network of individuals who had been identified as Smurfs. The investigation into Alvin Bragg also helped to uncover the use of prepaid credit and debit cards in the structuring of the campaign finance contributions and the payment of ballot harvesting mules. Does anyone find it interesting that Alvin Bragg charged Donald J. Trump criminally with a campaign finance violation while benefiting from a money laundering RICO enterprise? Has Alvin Bragg refunded all of the illegal campaign finance contributions made to his campaign? Yet. Buying the justice you want. This is systematic funneling of illicit campaign finance funds was also identified in the Wisconsin Supreme Court race of Janet, however you pronounce her name, I can't do it. The Janet for Justice campaign took in massive amounts of money from individual contributors who were also identified as part of the nationwide Act Blue money laundering RICO enterprise. How much does it take to buy a seat on the Wisconsin Supreme Court in 2023? Over $23.3 million was raised, mostly from leftist PACs, funded largely through Soros-linked organizations and the Act Blue money laundering enterprise. The nationwide Act Blue money mules and Smurfs made massive numbers of individual contributions to the PACs that largely financed the Janet for Justice campaign. So you see, it's not just one or two people. Oh, it gets serious, the accusations. And we all do know that it's allegedly. Should the people of Wisconsin be concerned about the purchase of a Wisconsin Supreme Court seat via a mass nationwide money laundering scheme using the stolen identities of the elderly? So what do y'all think? Should they be concerned? Okay, I got you. Okay. How many other judges and courts have been compromised nationwide at the federal, state, and local levels? They say follow the money. So we did. The information on Fani Willis campaign contributions was obtained directly from the State of Georgia Campaign Finance Database. And this is it. You guys can barely see that, but I had already went in there and pulled it up. This look a little bit bigger. So let's see if y'all can see this one, because that one is small. So let me stop sharing. And let me go back. And you might can see this better. Yeah, we all really should, Regina. We should really be concerned throughout. This is the kind of stuff we don't hear about and people won't report about. And we spend a lot of time reporting about a lot of nothing. And then we worry about our condition. But, you know, what can we do? We can do what we can do. It's not much we can do. But we can do what we can do. So this is the Georgia Campaign Finance, and I have that in the description. I have the link in the description. And this is Fani Willis's paperwork. Candidate for District Attorney of State in District Atlanta. Status active. Date registered 1/14/2021. And then you go on down. Everything on here is open record, so I didn't feel the need to do anything but to just go to the website just like they did. Okay, now look at this, y'all. This is the summary. Combined financial totals. Now, most people that I know that run for office never get this kind of money when they look like me. It's a few. And I'm not saying that people don't, but the majority of the people that I know don't. But total contributions, $326,042.33. Total expenditures, $122,672.02. Top contributors, Ross, these people, $13,000 is the top contributor. 4,000, 3,000, 3,000, 3,000. $21,988.52 was supposed to be anonymous. Individuals, $2,446.55. So that was 4,000. Y'all know what I said. I said it right the first time. I'm be done confused myself. Other, $51,775.77. Total of $3,016.10. Her expenditures. No category applies here. $910.74. Campaign consultants, $55,710.51. Campaign literature and mailings, $2,200. Candidate travel, lodging, and meals, $17,078.02. Contribution, explain, non-monetary, $4,000. Fundraising events, $14,247.10. Information technology cost, internet, email, $10,711.79. Meetings and appearances, $1,114.30. Other, $14,679.56. Now her top expenditures, and then she has professional service, legal, accounting was $2,020. Her top 5 payee, the expenditures was $55,710. That was to the Public Service Partners Limited. And then the Marriott Renaissance Harlem, she spent $7,196.68. The Paragon Solutions, $5,505.99. Delta Airlines, $5,348.40. And the Park at 14th, $5,000. And then you go over and see her filings. And she was late filing, but they waived all of the fines because she was not, I guess, that late. So they waived the late filings. So this one is the disclosure report. Starting period was 1/1/2024, ended 1/31/2024. The due date was 1/31/2024, and she filed it 2/7/2024. I guess they were too busy filing motions against Nathan Wade's wife during that time, so she couldn't pay attention to the campaign. And this is y'all can't see this, so I have to take that down, take that away, bring this back, because this really should disturb us all. This should disturb us all. View permissions. You can't change the documents or nothing like that. You can print it, but it's just telling you that you can't do anything to this document. That's what that's telling you. So we're not violating any codes or any rules, anything of that nature. But I want y'all to see what the forms look like. And I want y'all to see, I just want y'all to see the states that these people are donating. And do y'all really believe that these people that are in Virginia, Washington, maybe those in Georgia may be donating, I don't know, but you know, some of them have titles. But it's amazing how they're in Colorado. Some of them work for the sheriff's department. Some of them are attorneys. This person is not employed. They're in Illinois, not employed, but they're giving to the DA in Georgia. $101. Tempe, Arizona. They don't even know what their occupation is, but they gave $534. Public Service Partners in Colorado. Unknown occupation. unknown occupation. And they're very, very, very arrogant and rude. And this is the kind of stuff that they're doing. I haven't forgotten you all. I'm just looking at something else. Give me 1 minute. Okay, here's one. This one. Hi, Tasha. I just want y'all to tell me if y'all really believe that these people from all over the United States is really given to a little DA that nobody hardly know about but the people in Georgia. This report was for 2023. It was filed 1/26/2024. And this was from the year end of 2023 to 1/11/2024. And I want y'all to, and I'm looking at that. Like I said, I did put the link in the description. But I want y'all to see where these people that are contributing to this person, they're from all over the United States, and it's just hard to believe. Thank you. It's kind of like taking over, doing its own thing. It's kind of hard to believe that this is really true, but this is what they said. Okay. This attorney gave $2,500. Employer requested, gave $300. Retired individual gave $101. Unknown $501. Investigator $114. Information requested $1,000. Electrical engineer, electronic engineer $107. A professor $516. Executive $500. Accountant $500. Technical worker $51. Information requested $101. An attorney $516. Executive $101. Not employed $101. Manager $103. An analyst $3,000. Occupation unknown $1,001. Partner in Isaacson Miller occupation $103. Another lawyer $103. Maryland, California $1,000. Project manager, $15. A lawyer. And we're not saying that this can't be true, because people, give their money where they want. Not employed person, $10. Not employed, $10. It's just a lot of not employed for $10. And then certain occupations, which this is the same person. In Charles, he gave $50. He just gave $4 $50. $5 $50, $6 $50. Washington, D.C., Brooklyn, New York, Maryland, Georgia, D.C. And these people could have really given, all of this from all over the world. They really could have all over the United States. Smyrna, Georgia, Woodstock, Georgia. It's possible these people actually did this, But they said from their investigation, it's possible that they didn't. Brandywine, Maryland. And a lot of them, maybe it's because of the charge that they charge for donating. But a lot of them have, like this John Donnelly, he just gave the same amount each time. 101. He's in California. He gave 101 3 times. Those two gave 103, 45. So some people just give unless they're charging for, charging the card or something. Ohio, New York, 101. This person, I guess she gave every month, 51.83. Martha. She's in Atlanta. Jerry's in Florida. A lot of them occupations are unknown or not employed. Not employed. Unknown. Retired. And it goes on and on like that. And on and on. Retired. A lot of lawyers in Georgia, Noonan, Georgia, in the same offices. I didn't look at every single page, but I didn't see Wade. California, D.C. D.C. A lot of them for D.C. gave $250. Spring Valley, California. La Jolla, California. Conyers, Georgia. Just all over. All these people giving to the DA race in Georgia. Maybe because it was news and she was supposed to be the first African American and female. Who knows? But I just thought that was interesting. Chicago, Illinois. Just all over. All over. Maryland, a whole lot in Maryland, and all of these people maybe monthly contributor, because this David Longton, he gave $25. It looked like all on the same day. $25, $50, $25, $25. No, it's for the same election, but it's different days. The dates is over to the far left. Like a day or two apart, he gave. Every day he was giving $25, $25, $25, $25. Every day, $25. I just, almost find it hard to believe that David would give $25 every day. And look how long David gave, and he's not employed. David is not employed, but he's giving $25 a day, and some $25 the same day. David is giving an awful lot. And I'll just stop it there so y'all can really see it, and see I'm kind of speeding it, but you can really see. Let me see what y'all say. Okay. Yes, indeed. We should be all concerned, because it can happen anywhere. It's happening everywhere, y'all. But better believe it. Charlene, the lies, the lies, the lies. Good night, beloveds. Tasha's gone. Regina, okay. Lobbyist, okay. Regina, yes, I believe it. Fani has redefined DA. It now stands for dubious attorney. Regina M. A person do not have to know a candidate or what their ideologies are. They only need to know that they are part of the same thing. That's true, but they got to give it to them, though. They got to know that they are part of the same thing, but they got to give it to them. So they got to know that they exist to give it to them. That is very true. Especially when you think on the one train, here we go. Knowing what we know about Fani, those donations are unknown jobs. That must be her. Regina said, don't think so. But this person is unemployed, and they're giving every day. Sometimes twice a day. Unemployed. And he's given every day, twice a day, on some days, $25. And so maybe he just unemployed and have money that he can give like that. Now the nurse gave every month $5. Yeah, but so y'all got the idea. That's what we wanted, the idea. Just to see what it looks like. And some people would really, really think that we would be hating on this woman for getting what she's getting. And that's sad. Okay, so that's the expenditures, the filings, the fines. And like I said, on her fines, she was late, but they waived them all. They waived her fines. She was late. So I don't know if she's really, really, really business minded. And so they didn't find much, but she was late. 22, 23, 23, and then they waived them. She was late. So that's how that goes. We would love for them to waive some stuff for us sometimes. Okay, so let's get back to the article that took us to all of that. Let's go on down here. Back to the article. Okay. Okay, so now here is the first item we identified in the Fani Willis campaign finance report was that there were 222 contributions to her campaign that had zero donor information. No donor information. And then Peter had 12, Beverly 12, Alan 12, Greg 11, and these are the amounts of the contributions, the times of the contributions. Another point of interest was that many of the campaign contributions to the Fani Willis campaign were from out-of-state contributors. Many of these out-of-state contributors fit the profile of the Act Blue money laundering scheme victims and participants that we had identified in every single state across America. You can check the names for yourself using the FEC campaign finance database. And that's that little thing here, which we're not going to do that. But I do have this in the description, like I said, so you can go and do it on your own time. The out-of-state Smurfs raised significant suspicions. Why would elderly people who do not contribute to their own local elections be interested in making campaign contributions to a little unknown Georgia district attorney beginning in 2022? Hey, so Alicia, good to see you. Upon further investigation, a pattern seemed to emerge yet again. When contacted about making campaign contributions to Fani Willis, one of the elderly people on the list stated that she had never made a single campaign finance contribution to her campaign. She assured me that she had not made multiple campaign contributions. Another interesting pattern raised significant questions. Why had this particular campaign contributor been using addresses in multiple states to make campaign contributions? Upon further investigation, this Fani Willis campaign contributor was registered to vote in several states. Another individual Fani Willis campaign contributor who had made a single campaign contribution was also identified as an individual contributor making campaign finance contributions using addresses in multiple states to include Florida, Wisconsin, Illinois, and New York. Coincidentally, this individual made identical contributions via Act Blue to the same PACs and campaigns. This same individual was also listed as a registered voter in multiple states, casting vote by mail ballots. As we investigate, all of the individual contributors to the Fani Willis campaign and examine their ongoing contributions via Act Blue, we see that all of these individuals are making contributions to the same PACs and candidates. The ongoing pattern of activity appears to have started in great scale in 2018 and has rapidly accelerated at the federal, state, and local levels. One of the out-of-state Fani Willis campaign contributors had made over 9,178 individual contributions just at the federal level since 2018. What does it cost to buy the Atlanta District Attorney's race? And this is where this date filing was in 2023. How is it that so many people from out of state that are not employed are making so many campaign finance contributions to a little-known district attorney in Atlanta, Georgia, beginning in 2022? What is being seen at a growing and alarming rate is that the nationwide money laundering RICO enterprise is making more and more contributions to PACs, and these PACs are financing local candidates. Okay, I'll let that y'all hit that one for y'allself. It was showing that it was an auditor's race, and they spent so many thousands there, but it want me to take off my ad blocker and stuff, and it's just going through too much. I'm not doing all that. Okay, many of these PACs have strong ties to alarming rate. Is that the nationwide? Okay, I just read that. Many of these PACs have strong ties to numerous Soros-connected organizations that are active participants in the nationwide election fraud, money laundering, terrorist network financing, and the massive ongoing RICO enterprise. Since we first exposed the Act Blue enterprise funding, Warnock and the other Democratic candidates and PACs have started to shift the way that they have been operating. However, we have clearly identified who is involved and how they have been illegally influencing the outcomes of elections nationwide. The firm. These criminal organizations also share significant connections to the law firm Perkins Coie. This is the same law firm that was behind the false claims of Russian collusion or the part of the Trump campaign in 2016. The image below is an excerpt from the deposition of FBI agent Elvis Chang, where he admits that he conspired to censor Americans on big tech and social media platforms. Okay, and then they tell you about this, and you can go in and look at that. Those are court documents. Most large criminal money laundering enterprise functions with the assistance of willing attorneys and bankers. Perkins Coie is by far one of the largest beneficiaries of this RICO money laundering network. The firm received vast sums of illicit money via legal fees paid by the PACs and committees who helped launder the campaign finance contributions made in the name of over 1 million individuals whose identities have been stolen and used to structure financial transactions and circumvent federal campaign finance limits. The banks. Act Blue and the numerous PACs, nonprofits, and organizations have been utilizing the service of several large banking institutions. They are J.P. Morgan, Chase Bank, and Bank of America, and Amalgamated Bank. If these esteemed financial institutions had been doing any form of AML fraud detection and compliance, they would have filed suspicious activity reports and should have certainly raised alarms. Were these reports filed? Who failed to act? I think I need to stop for a minute and check my sinuses. One moment.
well established that Fani Willis is corrupt, but how corrupt is she exactly? You might recall that James O'Keefe did an expose on widespread laundering of campaign donations, allegedly being carried out by radical organizations like Act Blue.
Did you donate 8,000 times?
I cannot even if it were true, why is that an issue?
Well, it doesn't seem possible that you donated that many times.
You're right. It doesn't, so that's actually disturbing.
We're investigative reporters. We're just trying to figure out there's some fraud happening. This is your name on the FEC website.
I can't imagine that I did that. That's like impossible.
That's impossible.
It's impossible.
My name is James O'Keefe. Have you heard of that before?
Yes, I have.
You've heard of James O'Keefe?
Yes, wait. James O'Keefe.
Come in?
I'd want to come in.
Yeah, I'd come in, yeah. There's this data that we looked at from this man in Wisconsin who compiled all the FEC data, and your name in New Jersey was the top one.
And in an absolute truth, exclusive, one of the tipsters behind the investigation, Peter Berniger, has uncovered more evidence of what is called Smurfs, cutouts being used to funnel illicit funds to political candidates. He has poured through Fani Willis's donations and found evidence that these donations aren't coming from who they say they are. Like this example from Alberta, Michigan, from a place called the Cabbage Shed. Well, there's cabbage going through there all right, but it's probably not to Fulton County District Attorney Fani Willis. And this example from St. Petersburg, Florida, which looks to be, as you guessed it, just a vacant lot. Now, Florida Senator Marco Rubio's office has taken a look at these Smurfs and has filed a complaint about Act Blue and has demanded the FEC chair and vice chair investigate the radical activist arm of the Democratic Party. In Rubio's strongly worded letter, he says, quote, recently alarming reports emerged of fraudulent donations being reported to the FEC by Act Blue. These reports indicate that numerous individuals, including senior citizens, have purportedly donated to Act Blue thousands of times a year. However, according to recent investigative reports, many of these individuals had no idea that their names and addresses were being used to give thousands of dollars in political donations, with most of those donations going to Act Blue. It should come as no surprise that Act Blue serves as a vessel for fraud, considering the intentional lack of security ingrained within their donation processes and systems. Of course, the strongly worded letter must have gone promptly into the FEC's wastebasket because, as you might expect, no action has actually been taken against Act Blue. But there are rumblings in Georgia that Fani Willis is about to get her Fannie booted off that Trump RICO case. So we brought Peter Berniger himself here to explain what he's found looking into Fani's financials. Welcome to the show, Peter Berniger. He's an investigative, a citizen investigator, a citizen journalist, and he's done amazing work into what's going on in our elections across the country. Thanks for joining us again, Peter, and tell us what you have found.
Yeah, thank you, Emerald. Our team of data experts, we have run 2 campaign cycles of reports that Fani Willis's campaign herself filed to the state of Georgia. And what we found is 3 main issues of campaign finance violations.
Hi, Kelly. I just seen you came in. Now, they're looking at Fani's reports, y'all. This is not nobody else's. This is hers.
The first one is we found 220 donations made to her campaign and no name or address at all was provided on the campaign finance reports. Now, we looked it up under the state laws of Georgia. that is an automatic black and white violation. So there's 220 right there. That totals approximately $23,000. Now, that's a lot of money when you consider this is a Fulton County, Georgia district attorney race. District attorneys typically don't have these humongous sums that you might see in a national type race. So the first violation is the $23,000, and that's roughly approximately 5%. And I'm using round numbers so it's easier for everybody here today. So the second violation we found is regarding $27,000 in donations that were in excess of the $3,000 limit. So there's another more than 5%. So we're over 10% already of her total contributions to her two campaigns are in gross violation of Georgia campaign finance law. Now, here's the big one. We have been working on, and the numbers earlier that James O'Keefe was talking about in the video that you showed, we supplied those numbers to James, and we've been working with him across the country to expose smurfing. Smurfing is structured campaign money laundering. It's where the bad guys want to take a large sum of money, say $50 million, divvy it up into various campaigns across the country, including Fani Willis's, whereby they reduce the transaction amount, contribution amounts to very small amounts, from 50 cents, $3, $7, $25. But then they replicate those transactions by the tens of millions over the years. So this is now the big breaking news. We are filing today under sworn oath a complaint to the Georgia State Ethics Commission against Fani Willis of $160,000 in smurfing. This, you add these numbers up, and we're over 50% at least of all her money coming into her campaign it was unlawful, illegally obtained, and basically she cheated in her elections by using that money. Now, we know that there's what we call the classical smurf, which is a senior citizen. All these smurfs that we've been finding have no knowledge that their name and address are being used for these contributions to these campaigns. The money isn't going through their bank accounts, but their names and addresses are being used at the places of Act Blue, Emily's List, the DCCC or DCN, and other similar liberal PACs to launder these large sums through these names and addresses of these unsuspecting citizens. Now, on top of that is based on private investigators that we've hired, based on the James O'Keefe team interviewing these people across the country, based on journalists and volunteer citizens. Interviewing people on camera across the nation at their homes, we know 100% of them so far have been senior citizens over to the age of 65 and typically into the 70s, 80s, and even 90s. So this is identity theft, this is elderly financial abuse, and this is criminal money laundering. And we're filing a complaint today against Fani Willis to hold her accountable.
What kind of, okay, so let's talk about in accountability. You filed a complaint. What action would you expect and hope would be taken?
Well, we know that they go through a flow chart process. They typically have a staff attorney review the complaint first. We provide the data and we tell them the sources and how we came to the conclusions that this money was laundered. So all that evidence is supplied to them, and then they pick it up and they decide whether there's going to be an investigation or not.
And then one would think you would go to investigation. So this was a total of about $168,000 you say resulted from smurfing. What was her total? What did she raise in total for that cycle? How much of a percentage did this encompass of the total donation?
The one campaign cycle was $226,000, and the second one, I don't have it. I don't have it. The gross total. So then the second one was less than that. So you're well over 50%, maybe 60% of all her campaign contributions coming in with the 3 different issues that I listed. She's using fraudulent, unlawful money to run and fund her campaigns.
That is a huge percentage, Peter. Even if it was 20%, 30%, that would be a massive amount, right? 10% would be a big amount, but we're talking about over 50%. That's totally propped her up.
Yes, we are. And in addition to that, since we're talking about Georgia, somebody who is probably the poster boy for this across the nation, besides Joe Biden, is Warnock for Senate. He probably is the number one in all the campaign candidates that we've examined across the country. He is by far the number one in excess Smurf donations, and we'll be filing a complaint against him also.
When do you expect to file that complaint?
Well, the Fani Willis one is going in today, and I would imagine that within about a week to 10 days, we'll finish up on Warnock for Senate.
Okay, so the complaint goes in today. Sometimes they can take a long time to get a response, but given that she is currently, I mean, she's got a lot going on right now, but she's still actively prosecuting the former president of the United States of America, which is probably one reason they wanted to prop her up, let's be honest. How long do you think it will take to get a response from the board?
Well, what else we're going to be doing is I'll be sending a copy of the complaint to some grassroots people down in Georgia, and then let them encourage them to file with the Fulton County Sheriff.
Because technically this would be a law enforcement issue, right? And that's what we forget about a lot with some of these elections violations. Everyone just goes to the State Board of Elections. There's some kind of ceremonial investigation. There's a slap on the wrist and nothing really happens. But one aspect that gets left out of this is that it's a violation of the law. So there is jurisdiction. For county sheriffs, correct?
Of course. And again, remember, this is identity theft. This is elderly financial abuse. This is criminal money laundering. This is bank fraud because obviously the transactions are going through the banks. So there's a multiple and it's cheating in the election. Now, I don't know what statute in Georgia that would be under, but she cheated in her election by using this unlawful money to run her campaigns.
Real quick, we got 20 seconds. Would this be grounds for removal, or would this require some kind of impeachment from the legislature? What would you look at for in a response from state lawmakers?
My response, I'd be looking for a response that they go arrest her and indict her.
Okay. All right. Well, that complaint's going in today. We'll continue to follow this story because this is a huge finding, Peter. This is massive fraud that you have uncovered here. We'll continue to cover the story as it develops, and hopefully we'll hear something back from one of the entities that you provided this report to in your complaint. Thank you so much, Peter Berniger, for all you're doing and your team, and give them our best.
Thank you.
And Regina, you're so right, but all of it could be false. I don't know. That's why we just report the news and put out our disclaimers. But one thing you can do is I did put the links in my description so you can actually go and download all of the contributors, and you can go to the website that they have in there and cross-reference for yourself. That's the only thing I would suggest anybody to do, to always, if you want to know something, do your own research, because it's so much, as they say, fake news out here, to sometimes you can't tell the real from the fake. But these reports are with the Georgia Finance Department, and they speak for themselves. So you never really know what's going on. And it's a lot of people. This, this article, that was the pundit. That's the article that I was reading from. And I didn't do any research on the guy. I just got the articles, and they all came off of X. A lot of people report different things, and this is one of the things they reported from September of 2023, and then this year when they filed that complaint in February. So we'll see if anything come of it, but they all are big PACs and lobbyists, and they all do what they do. It's just like they said that, she was broke when she was at the trial, but if you look her up on the internet, it says she's worth $8 million. So the $8 million came from somewhere. I don't know where, but it's just hard to believe. In 2 years, she became a great investor and came up with $8 million, especially since she's one that keeps all the cash at, the crib, as she say. So that's Fani Willis and what she's doing with the money. It was amazing to see some of the meals that she had, some of the dinners that she had when she was out of town, and the expenditures that she would have. They were pretty high, and I thought I had them already opened, and so I can't find that document. I have so much stuff, and that's sometimes the reason why this thing doesn't go quite why it buffers, and it's because they said sometimes you can have too many things open. But that's really going to be interesting to see, and to see what's going on. It's possible that maybe people in Georgia and some of those grassroots are really out there working the streets, and hopefully people will get interested and start looking up these people that they have to vote for and see what they stand for and what they've done, and she hasn't voted on anything, but to see how she treat people, because the way they're handling themselves in public is terrible. And this thing with this Adrian Love today, it was just so disheartening. And I don't know, I want to really try to believe in this judge, but I mean, every time I think that he's almost on his way to being fair, he goes completely the opposite way. Regina said, I always do my own research, and I am an advocate for truth and fair justice. The justice system is broken and corrupted by greed. It is no different than most things in this capitalistic world. That is true. You can say in this human world. It doesn't matter what they call it. As long as we have humans, we're going to have corruptions. Even when we had the best of the humans, they say, they were corrupt. That's just a part of being human. But one thing I love about you, you are going to do your research and then you're going to share it with us. So that's what I appreciate, because I'm about truth and seeking truth for yourself. Don't take my word for anything, which this is not my word. I'm just reporting this story. But don't take it. Look for yourself. And Regina is truly a learned individual. One of the most learned I've talked to, and we've only talked in the chat. But you are awesome with your knowledge, and I appreciate it every step of the way. So with this trial today, you know what gets me with this judge is that he said a couple of weeks ago, because the state never produces all of the evidence, they didn't do it when they should have done it because they have time schedules, and when they have to do it, they should get it to the defense before it's time for them to go in trial, so that he doesn't have to send the jury back and have a hearing on it. They do nothing right. And they had a situation to come up today. Yes, ma'am, I do know you do. I love you dearly. So always keep being Regina M. Always. Don't you ever stop. I don't care if you have to correct me, if you have to help me, or whichever way it is. Encourage me. Don't ever stop. Whichever one you have to do. I love it. And I truly love your honesty and your intellect, because it's real. And I appreciate it. I don't know about nobody else. So I could be out here to help somebody, but you certainly helps me. And that's with all of you guys that come and offer what you have to give. Because we all need to help each other, really. And we certainly need to encourage one another if we can't do nothing else. And hold each other accountable. Tell each other the truth. It has a way of dealing with you when you're by yourself. If you're a believer, when it's just you and him. It's you and whoever, whatever you believe in. It has a way of dealing with you. And it helps fine-tune your discernment. It really does. But this judge here, he made a decision today that I was really proud of. He wouldn't allow this lady to play a certain thing in the court. And she can never sustain when he's talking about her. He always has to talk back, has to have something to say. And I tried to find that, but when it's live, you can't get a timestamp. I wanted to find that when they were up there talking, and then when he made the decision, and then he allowed her to talk him into changing his mind. And that was really painful. When he allowed this woman to talk him into changing his mind. And these attorneys are some brilliant attorneys. And they went to work. So we're going to look at some of Young Thug. And it's the lady that's on here called Infamous Sylvia. And she's in the courtroom every day. She goes to different trials and sits and stream the trials live, and then give us play-by-play of, what's happening actually in the courtroom, the things we can't see. But this is what she does, and she does a great job of it. And you know, she tells us the atmosphere in the room and the different things that's going on. And I normally look at law and crime. I like both. She said that they're in competition, and she's such a small person, but she said they put another person in there on her. Regina, who you talking to? Why? You talking to me, Regina? Talking about why? Okay, I don't know if you're talking about me or not, but tell me if you're talking about me, why? But anywho, so I want y'all to see this, but I don't know where we are in the video because I tried my best to go back to where they were when they were doing the sidebar, and then they came back. But it's very hard to listen to this woman because she has this. Oh, she said that's what she does. She said she go to a lot of trials all over, not just in Georgia. She said she go all over. That's what she does. She's married, so I don't know how she did it, but I guess maybe she called herself a reporter. You know, maybe that's what she like. I don't really know. I haven't heard, you know, her storyline, but I did hear that today because different people be asking her about her being in the courtroom. But she said she has went all over the United States to different trials, and she go and she streamed them. So maybe she's fascinated with trials. I really don't know. But let's see if we can, if this is not the part, then I'm just going to tell y'all about the part like I just did, and then let y'all hear what Mr. Keith Adams had to say. Now, this has been a detective who's been on the witness stand for 4 days, and this lady has no reports, no paperwork, been retired for 4 years, and she can go back and tell them everything that happened with all of these gangs and stuff. And this is the same lady who didn't answer the phone when she worked in the call center, and they promoted her up because they saw she didn't like answering the phones. Yeah, I look at it on TV. You know, I look at different courts and things on TV. And Phyllis like to look at court TV too. But she actually goes, and perhaps too, she may be a Young Thug, fan. He seemed to have a lot of fans. I didn't know a lot about Young Thug, only that he was a mumble rapper like most of those Southern guys are. So I really didn't know a lot about him. But he's been there every single day since the trial started. And she's there every day, she said, unless she gets sick, and so far she hasn't. But you hear a lot of coughing and sneezing and all that in the courtroom. But he really be there. Let's see where the judge is right here. It's almost real hard listening to Miss Love, for real. And she's been trying to put on her baby voice. I don't know if someone said something to her from the other day. Regina, you cold. Let me see where we are here.
Apologize.
Okay, y'all, let's see what this is.
And the other issues that the court would take up at that point in time as to what it would play and for what purpose. Okay, so I'm going to sustain the objection right now, but if you can lay more foundation another time, I'll reconsider it, okay?
Yes, Your Honor, and to understand, Your Honor, is the court saying that only postings of a party opponent on the party opponent's website can be?
No. It has you have multiple issues with this particular piece of evidence. We haven't gotten to the reason that you want to put it in. That's separate, okay? The first part has to be the foundational aspect of, is it true and is it authentic? So in order for you to do that, you need to show where the original posting came from, so there's no alteration of that particular post. I would need to see that in order for me to kind of make a further decisions on whether or not that particular statement is admissible. I mean, so I'll get to that. But I think that if you can show that where it came from to begin with, that there's some reliability that, hey, it came from Mr. Williams' website or a post from Mr. Williams, then I'll reconsider it at that point in time. I just haven't heard any testimony about that.
I didn't know if the court saw at the bottom, it said at Thugger 1, it referred to Mr. Williams' website.
I understand that.
And so,
but it's still a reposting.
And in doing so, Mr. Garlington was adoptively admitting Mr. Williams' word. As our evidence book says, statements of a party opponent are admissible without presenting predicate or foundation. The definitional exemption for individuals.
Where's that?
It's on page 463. It's in 24-801 D2A. It's
24-8 what?
801 D.
Ladies, I want y'all to please weigh in on this I want y'all to weigh in on this. Listen to what she's saying, and then listen to the arguments. And then let's see.
4-8 what?
801, Your Honor. Delta 2 Alpha. And it is under the heading Foundational Factors. And for the court's edification, it's the 8th edition, page 463, the 3rd paragraph down.
What paragraph? I'm sorry.
It is paragraph 3 that starts with statements of a party opponent are admissible without presentation of any predicate or foundation. The definitional exemption for individual admissions is extortions having almost infinite breadth. In addition, an admission of a party opponent needs no indicia of trustworthiness to be admitted. The party admission must be relevant, and the party admissions are not subject to the personal knowledge requirements of Federal Rules of Evidence 602. In addition, courts recognize the freedom that admissions enjoy from, quote, the restrictive influences of the opinion rule. They go on to point to the fact that the District of Columbia Court of Appeals explained the generous treatment that the introduction of party admission receives. Party admissions differ from most out-of-court statements in that their admissibility does not require the demonstration of guarantees of trustworthiness, but is based rather upon the identity of the speaker. Therefore, party admissions do not require foundations to be admissible as substantive evidence. They need not have been made on personal knowledge and may be in opinion form so long as the statement is fairly attributable to the party. It makes no difference whether the adopting party had any personal knowledge of the truth of the matters mentioned in the statement. And then it goes on to show.
That's plenty. All right, Ms. Steele, I'll give you the last word because it looks like I may have read too early. So.
I believe you read too early. Statement of a party admission has to be an admission.
Party opponent.
Admission by a party opponent, I thought.
Admission by a party opponent. Yes, sir.
An admission has a specific text and connotation in law. It's different than a confession, which admits all elements. An admission admits some of the elements. Here, this is a statement. The state still has to be bound by the foundational requirements that you have sustained the objection.
Okay, stop. Please,
yes, sir.
Please don't go back to that. I have to make them on an individual basis, all right? So why wouldn't this be an admission of a party opponent, your client, if a jury chose to believe it?
Because 3 reasons, and you've already said it. They don't have a date.
But it looks like from looking at Carlson and 24-8-801D2 alpha, that's what it indicates here, that statements of a party opponent are admissible without presentation of any predicate or foundation.
Because it's not an admission, so you still need the foundation.
Why wouldn't it be an admission? If it's believed by the jury for what it stated in the statement, it goes to whether or not your client's a leader. It goes to whether or not he has control. It goes to several other purposes that the state mentioned earlier in terms of his relationship to YSL, intent. So if the jury believes that, because that's certainly within their purview, but why wouldn't it be a party admission by a party opponent for that reason?
Because the state is saying they charge it an overt act, that this statement was made, reposted on the 26th day of January 2015. There's no evidence of that.
But it looks like, I'm sorry, go ahead, sir, I apologize. Go ahead, I'm sorry, go ahead.
My position is it's not an admission without there's some sort of context. This was said for this reason, to stop people from cooperating, or this was said for this reason.
But that's what the jury needs to decide on that issue.
Foundational requirement, like you've said.
I
believe the foundation still is the.
Okay. While I did say that, Mr. Steele, it looks like that. Of course, I have to look at things in the light of what you all tell me, and also the statutes and the law applicable. But it appears that it looks like from statements of a party opponent are admissible without presentation. If I believe that the statements in 112 Bravo, the digital media from January 26, 2015 are in fact an admission against interest.
Well, I don't believe.
Or admission of a party opponent, I should say.
I don't believe that it fits in that category because we don't have any of the date that it was made. If it was truly that statement of Mr. Williams, I still say that the state, they started out with, it's all Mr. Williams' statement and there's nothing else said except yeah, and indiscernible. That's wrong. Then they started out with, they don't have to identify the speaker. I believe that's wrong. And now they are at a position where they don't have to lay any foundation because it has to be an admission of a party.
But it looks like under 24-8-801D2A that it's not required.
Okay.
It's not required.
Well, then,
and I'm looking at the statute right now, and it says, admission shall not be excluded by the hearsay rule. Admission is a statement offered against the party. A statement means an oral or written assertion or a nonverbal contact of a person is if it's intended by the person as an assertion. Your client is allegedly making a statement in this particular video, which arguably is an admission by a party opponent for what the state is claiming in Act 26, as well as count 1. So, I mean, and that's for the jury to decide, but whether or not they want to take it as that. But it appears that if I'm reading 801D2A correctly, that the foundation has been met.
Well, then I didn't know about this when we broke. If I would have known about this issue, I would have done it over the break. I just learned about it. I'm assuming when the court learned about the state's new position, I'd like time to look at it because my memory is this is not an admission, but I have to get you the cases. I can't cite a case to you off the top of my head. I apologize, but I can't do it.
No, I mean, look, I'll give you 5 or 10 minutes if you can find me a case that says it's not a statement against interest or a statement by a party opponent, but admission by a party opponent. I'll take that into consideration, sir, okay?
Thank you.
All right. So I'm just gonna pause for just about 10 minutes and I'll go ahead and let you all confer about that, okay?
To try to find the case.
Where's Mr. Steele? Oh, there he is. Okay, all right. Let me go ahead and just as an opening kind of to the court's addendum, just tell you that I'm only going to consider the statement and want to hear argument as to whether or not it falls within 24-8-801 D2A, because from doing a little more research, if it's an admission against interest in the statements in the criminal case, and is the case law, and I'm looking at Anderson versus the state, 360 Georgia App 291. If it's in a criminal case, exposes that the declarant to criminal liability is showing must be shown of the corroborating circumstances that clearly indicate trustworthiness of the statement. So my original ruling would stand on that issue, that you'd have to be able to show where it came from, even though generally a repost can't be changed, but I don't know that. So I would have to hear something about that. So I'm not gonna take it as a statement against interest. I will, however, hear any argument as to whether or not it still falls within an admission by a party opponent.
Does the court have a preference for when each side speaks?
Okay, go ahead.
So, Your Honor, under 24-8-801 D2A, admissions by a party opponent, I believe the question raised was whether it was an admission. 24-8-801 defines statement as an oral or written assertion. In this particular case, there was an oral assertion that if you lie to your folks and get in court and tell the truth, you need to be killed. That's from me and YSL. But 24-8-801 also defines a statement as nonverbal conduct of a person. The nonverbal conduct was capturing himself saying that, memorializing the assertion, the oral assertion that he made. So the exhibit itself qualifies as a statement because it contains both oral assertions and nonverbal conduct. And so therefore, under 24-8-801 D2A, It is a statement of a party opponent, which is admissible without the presentation of predicate, any predicate or foundation. Additionally, Your Honor, 24.801 D2E would make anything said by the people behind him who are co-signing as to what he is saying, co-conspirator statements. They are literally.
We don't know who they
Right.
are, so.
Right. And so what we hear happening by the primary and only relevant speaker, and that being the defendant Williams, is as he is saying, y'all need to get killed, bro. That's from, there's no rejection or rebuking or anything like that of the snitching bitching statements. So essentially, he's adopting those as his own as well.
He being Mr. Williams, so purportedly, right?
Yes.
Okay.
And so we primarily stand on the admissions by a party opponent, and as to the commentary that is also heard, we would argue that Mr. Williams has adopted those, and that any argument to the contrary goes to the weight and not the admissibility of the statements. And the jury is the proper entity to weigh that statement.
All right, madam.
Thank you.
Mr. Steele?
Your Honor, I found a case. It's United States versus Rodriguez, which is R-O-D-R-I-G-U-E-Z.
One more time.
Yes,
Is
sir.
it R-O-D-R-I-G-E-S-Z?
R-I-G-U-E-Z. R-O-D-R-I-G. G-U-E-Z.
Yes, sir.
And it's 427, Fed, which is FED period, appendix APPX period, 784,
One more time, I said
yes, sir, 427,
427.
Fed,
I'm
FED
sorry.
period, appendix APPX period,
You said Fed appendix?
yeah, FED period, APPX period, 784.
All right.
It's in division
Let me see if I can find it.
C1.
Hold on 1 second.
And is this a 2011 case?
Yes,
It looks like it's 2011. Is that correct, Mr. Steele?
correct, May 25, 2011.
That would be before the new evidence code.
Right,
took
in
effect.
Georgia, but it's 11th Circuit, so we adopted their evidence code. That's what we did. So this would be the law that from the 11th Circuit.
All right, so what section are you asking or inviting my attention to?
C and then 1. It's maybe halfway down in the opinion.
C and then 1?
Yeah,
Okay.
so it starts with C and it's titled, "The District Court did not abuse its discretion in admitting evidence." There's a paragraph explaining it and then it goes into 1.
Hold on 1 second, sir. Is it the letter C in terms of,
Yeah.
okay, hold on 1 second.
It's in, under Roman numeral 3, it says discussion. and then it starts with A, B, and then C, and then 1.
I'm with you.
Okay, and then, I mean, it's a short passage, we could read the whole thing, but I liked it because it targeted both what you said to us, and I heard what you said after I found it, but 801 D2A as well as 801 D2E, it was in the same case. And in the third paragraph of Division 1, it states that the district court also acted within its discretion when it concluded that circumstantial evidence coupled with Rodriguez's self-identification authenticated the telephone conversation sufficiently to satisfy Federal Rule 901, which is corresponding to Georgia 24-9-901, which provides that the requirement of authentication or identification as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. And that's what the court just found, and what I've been saying, they don't have, to my knowledge, right now, any evidence that this repost is what it was originally. They don't have the date on the original statement. So that is my position again.
We don't, in 24-801 D2A, which is our statute, it has no requirement of date and time as Mr. Steele is asserting.
Authenticity.
And
That's different. Authenticity is different.
Is that?
Authenticity is different. It's 901. Okay. But, okay, but, Mr. Steele, that would only be, for example, if I couldn't, or nobody could make out that that's purportedly your client, that would be indicia that it's not reliable, okay? But there's nothing in there that's shown that the postings have been distorted. It's not readable. It's grainy, whatever. So there's sufficient indicia that that's your client. I mean, I would argue that from looking at what the state has tendered or proposes to tender as in this exhibit. 111, I should say 112, Bravo.
I'm not claiming that someone reasonably did not say that's just the way. I'm not claiming.
But that goes to 901, and it goes to whether or not it could reasonably be that it's your client and there's other and it's reliable. So.
Is there something beforehand? Is there something after? The words change. The other speakers are unidentified.
But there's nothing in there that would indicate to the court that has occurred. if there was, I would certainly take your argument, and that would be more applicable. But I understand, sir. I'm gonna basically overrule that particular. I'm not gonna overrule it, but I'm gonna go ahead and I'm considering it for the proposition. It is.
Your Honor, in regards to the statements of other people on that video, those are not admissions by Mr. Williams. So are those being redacted? I recall, despite what was said at the bench, that the tape actually, I think at one point someone says this is from YSL, B word, or something like that. And those were not words of Mr. Williams.
Okay, but Mr. Williams, if you believe the state's argument, and the jury can decide for themselves, he's co-opting that particular person's statement as to the circumstances.
Well, and I have an argument about that. Essentially, what we're talking about under the law is the case law refers to as an adoptive admission, and two things.
Well, no, it's different because you're still dealing with a statements of a party opponent. Okay.
Right, but if it's not the person, if it's not the party itself making the statement, then the only way it's admissible is if it's adopted by the party. That's what an adopted admission is. And according to the 11th Circuit and the case law, it's very limited case law in Georgia, but two criteria must be met. First, the situation must be such that the innocent would normally be induced to respond to the words of the other person. And second, there must be sufficient foundational facts from which it can be inferred that the defendant heard, understood, and acquiesced to the said statement. And this is my argument. It's going to be by analogy. I'm on the phone with Mr. Steele. We're talking about the day we were in court, and then Mr. Steele says, and Max, remember that armed robbery that we did in 2020? And then he hangs up the phone. Well, I didn't have much of.
That's a little different.
Well,
hey, because that's called a tacit admission. That's a statement that somebody listen. That's a statement that somebody makes that you expect them to say. It's just like like somebody who says, did you hit Frank? I didn't.
Well, right.
You'd expect somebody to deny that immediately.
Correct, but from my recollection of watching the post. That last part was said at the very end of the post, and there was really no opportunity to respond, to acquiesce, to do anything, and then the post ended. So my argument is, I agree with Mr. Steele that it should not be admitted at all, and that's my stance. But if it is going to be admitted, the words of a third party, I don't believe that Mr. Williams' lack of chastising the person, whoever said it, in the 1 second that the clip continued before it was turned off, constitutes an adoptive admission. And so that's my stance.
Thank you, sir. All right, State, you wish to be heard on that issue.
Yes, Your Honor. What is happening, as the court heard, is that the person who is echoing Mr. Williams' comments about people who come into court and tell the truth need to get killed, that's from him and YSL. They're actually echoing Mr. Williams' statement as opposed to Mr. Williams' statement simply adopting his. The other thing that I would point out is that this is a much different situation than, say, someone taking a selfie and getting photobombed unknowingly by Mr. Brown standing behind me until I look at the picture. Mr. Williams has a camera up to his face. He is video recording himself. And it's audible to a listener that words are being spoken. He did not have to keep that recording. So his nonverbal conduct was the recording of himself and the capturing of that echoing or that co-signing of the person who is signing on to what he just said. It's not a simple matter of Mr. Williams adopting or not adopting the person behind him. It's the person behind him echoing and adopting his admission. And by recording himself and that person on that video recording, Mr. Williams is essentially signing on to the sign-on, if you will. He is agreeing with what that person is saying. They are synonymous. Snitching bitches is the last thing I think that someone said, and that is essentially the same as you come into court and tell the truth, you need to get killed. That's from me and YSL. And so as you stated earlier, Your Honor, under 24-8801 D2A, given the definition of statement as both an oral assertion and as a nonverbal conduct, the oral assertion qualifies as a statement that Mr. Williams is making, that a person who comes in and testifies should get killed from him and YSL, and the nonverbal conduct is recording himself and the person co-signing with him on a videotaped medium.
Your Honor, the state in their argument just made a whole bunch of assumptions that there's no evidence to support. They just stated that Mr. Williams was taping himself. I don't know how we can make that determination. They said that Mr. Williams decided to post it himself. I don't know how we can make that determination, and that's the whole point. We don't know these things. There's a lack of foundation.
In terms of what, sir?
Well, I mean, they just said that Mr. Williams taped himself. I'm not agreeing to that. They're saying Mr. Williams chose to post it on the internet. I'm not agreeing to that. So these are the foundational requirements that they're just kind of stating it as so, but I don't believe that that's been proven. So, and that's relevant to the issue of the adoptive admission part, or as you called it, I think we're talking about the same thing. You call it a tacit admission, I call it adoptive admission. I think essentially we're talking about the same thing.
Sir, I'm sorry.
I will say this, I don't personally have any knowledge that this is on Mr. Williams' social media. I've looked, I cannot find it. If I'm wrong, I know the state didn't give it to me. Discovery like that, and I don't find it. And I'm not going to repeat myself, but we started this whole thing with there's no other person in the background except yay. Now other people are saying things in the background, but it shifted so much. And I just still think that the bottom line is somebody, the proponent of the evidence is the state of Georgia, somebody has to come in and say, yeah, this wasn't altered, this is when it was made, and this is accurate. And we don't have that. What if this was made, Your Honor, in 2014?
But the challenge is that under current Georgia law, as it pertains to admissions by a party opponent, it's admissible without presentation of predicate or foundation. Unlike if you have a statement against interest, or unlike if you've got conspiratorial statements, there are a couple other things that need to be brought up. But this particular statement is being offered for the admission by a party opponent, and that's what the law provides under 24-8-801 D2A.
Not really, because if you recall, it's posted, the state said being offered as a statement also of a party co-conspirator, excuse me.
Okay, that's different. That would be under E.
Right.
And E requires different, but however, looking at E as well, conspiracy need not be charged in order for OCGA 24-8-801D2E to apply. For evidence to be admissible under this rule, the government must prove the existence of a conspiracy by preponderance of the evidence. In considering whether a conspiracy exists was established for purposes of this rule, courts do not require the conspiracy to be proven prior to the admission of the evidence in question, but only that the conspiracy was proven at trial. So, but their primary purpose is under 801D2A.
Please correct me, but I believe the foundation is needed because remember how the state is using it. They're saying they charge it like this. They put it in the overt act. I think you said 26. I can't remember. I think you said that. They put it as a repost or posting by Mr. Garlington. It's not Mr. Garlington's statement. They're saying that it's Mr. Garlington's statement to warn people because they're in a conspiracy, so it's a co-conspirator statement. So I still believe that the statement originally by Mr. Williams has to be authenticated, as we've been discussing.
The law does, I don't think it does. I mean, there's nothing in here that says that that statement has to be authenticated. It just says co-conspirator statements may be admitted when the prosecution shows by a preponderance of the evidence that a conspiracy existed, 2, that a conspiracy included the declarant and the defendant against whom the statement is offered, and 3, the statement was made during the course and in furtherance of the conspiracy. Where statements, however, admit participation in crime but do not evince an intent to commit further criminal activity, Rule 801D2E does not authorize their introduction. I would submit from the court's perspective that the statements could be considered by the jury for the other purposes of what your client said about people coming into court, making purported statements. So I believe that it would satisfy still the dictates of 801D2E, but remember the state's offering it under 801 for count 26, but also for the overt act under count 1.
So,
And I'll give that. We can hash out that when I charge the jury. Well, because it's going to depend upon some other things if we get to that point, and some other things that may develop in this case. So I'm not saying to you that we may not have a distinction between that, but at this point, I believe it'd be admissible.
okay, and listen, I respect your ruling, but that's why I found the Rodriguez case, because it discusses both 801D2A and 801D2E in the same C1 section, and they discuss specifically the authenticity under 901. That's why I thought it was a good case.
Okay, I understand. State have any further comment about that?
Your Honor, we believe 24-801D2A is clear as it relates to foundational factors. And that, along with the policy and rationale behind it, makes the evidence that the state seeks to admit allowable, and we ask.
Okay. All right. I'm going to allow the state, allow the States 112 Bravo Bravo, the statement made on January 26th of 2015, over objection. And I'll make it a continuing objection to all concerned. Okay, all right. Yes, sir.
Before the jury comes back in, can I ask?
Now, this is going to be some real truth. I want y'all to listen to this and hear Mr. Adams. And he's going to get to cross-examine this detective. They did this to weigh out this evening so that he couldn't start his cross with her. And so they're giving her, because the court is going to be off, y'all, tomorrow, Friday, Saturday, and Sunday. So they're going to be working with her real hard for the next 4 days, because he's going to be the one that cross-examines her. And it's going to start Monday morning. These people are working together, and they're not working for righteousness' sake, in my opinion. But let's hear Mr. Adams as he tell the judge what he just had to say before they ended court.
Else?
Your ruling's done. You've already ruled. That's fine. We accept that. I want to address something to the further bench that I want the court to address.
Sure.
And I just need about 3 or 4 minutes. I've got to say this because I've been sitting there after our conversations. Let me just preface it by saying, in any of our objections, whatever, you make a ruling, sometimes we win, sometimes we lose, we move on. That's fine. If after your ruling, I've got a case that I want to bring to your attention, I say, Judge, reconsider your ruling based on this case, and you consider it, that's fine. If you don't want to consider it, that's fine too. But what I found objectionable, and I want the court to address with the state, is what happened at the bench earlier. There was an objection to the video. You made a ruling, we moved on. The state came back up and made representations to you. And they weren't representations based upon some new case law that they had found. There were representations, misrepresentations that were made directly to you, all of us standing there right there at the bench. She said something very, very fact specific in an attempt to get you to readdress the issue again. Madam Prosecutor said, I want you to listen to the 17-second video, because what you had based your ruling on was that the parties in the background couldn't be identified, all right? And Madam Prosecutor said to you, and was not accurate, and I'm gonna be charitable and say that she was disingenuous. What she said was, these people in the background, the only thing that you hear are people saying, yeah, yeah. That's it. When Mr. Steele corrected her and said that's not true, she said, Mrs. Steele is not accurate. What Mrs. Steele just told you is not true. The only thing you can hear in the background is yeah, yeah. And actually, when she stepped up there, it was in an attempt to act as though she didn't know what your ruling previously was, because their attempt was to go ahead and play the video at that time, despite your previous ruling. My point is this. After you decided to reconsider, you want to hear the video yourself, you had a chance to hear it. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio that were in contradiction of what Madam Prosecutor said. On God, snitching bitches. I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro. Fuck nigga. I'm not just saying that for emphasis. I'm saying that because what she said to you was inaccurate. At some point, Your Honor, I'm asking you to, we've had this conversation about candor with the court over the course of the past number of weeks.
3.3.
Yeah, we've had that conversation about it. And when we step up to you and we make a representation, it ought to be candid and it ought to be truthful. And what she said, and look, if she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right. You heard Mr. Steele. Mr. Steele said, Your Honor, I am willing to surrender my bar card and have her surrender her bar card if what she is saying is true. He wasn't wrong. She wasn't wrong. She was not candid with the court. And at some point, you've got to say to the parties, if I'd done that, I would expect you to say, Mr. Adams, don't do that again. Don't step up to me and lie to try and get me to rule or overrule something I've already ruled on. Don't do it again. You ought to say that to them. We're not playing games in this courtroom. These are these people's lives at stake. And like I said, sometimes you win a motion, sometimes you lose. But you don't get the court to address something or readdress something like that. That's all. Say something to them is all I'm requesting.
All right, sir.
Yes.
You may.
Your Honor, I would not have asked the court to listen to the 17-second video.
But what you did tell me, Ms. Love, wasn't the entirety of what was purportedly on states 112 Bravo. It did have other statements on it. It's different if you'd have told me, Judge, there are statements on there. Probably need to listen to them for yourself. Not just yeah.
Your Honor, my recollection, and I'm going to speak candidly because it's been
I would hope
along.
there'd be nothing less than candor.
And Your Honor, that's what I've been pushing for all along. There have been times, as the court is aware, that we have been at the bench and misrepresentations, bald misrepresentations have been made, and the court has seen my reaction to them. I am the one that's constantly saying I have a duty of candor to the court.
All of you do. All of you do.
We do. And when Mr. Adams just read those series of things that he read, those half of what he said, I didn't catch. The part that I did catch and remember is the part I kept repeating just now, snitching bitches. And I didn't even recall that part was there. But what I did know was that the relevant portion and the relevant speaker was Mr. Williams. And Your Honor, I'd ask, we can do this in chambers or wherever, but Your Honor, I believe that certain requests and comments to the court have risen to a level of being not true motions or requests based on legal analyses, but more leveled specifically on a personal level, which I've attempted to stay away from. Whatever one's reason for doing what they do, if it's to better advocate for their client, that is fine, they're entitled.
Well, you're not entitled to do everything in whatever position you're from, be it the state or be it the defendants, because you have a overall right of candor, responsibility of candor to the court.
I agree, Your Honor.
There are certain things you just cannot do anyways. Zealous advocacy is one thing, but it should never be confused for misstatements or for anything else that's not less than candid to the court. I think both sides, you all are fighting very diligently and valiantly about your respective sides. And as I said a couple of days ago, what the public sees is there's friction between the state, the defense, and the court. That is natural, and it is good for the system because it shows that that we are not in collusion with one another. Justice is what it will be, and whatever this jury will decide. But what I am going to just advise everyone to kind of relook is what you tell each other, what you tell me, because there have been times where I have not received, I would consider what is accurate information. Let me just put it that way. Okay, and I know, and I'm not trying to attribute, dishonesty to any party, but I have to rely, all courts have to rely upon counsel for their representation. So if you can't remember what it is, just tell me that. It's just like your duty to, when upon asked if there's any adverse position to this particular statute of law, you're required to tell me. I mean, I understand there's zealous advocacy, but I would also just remind everybody within the sound of my voice, professionalism really does matter to you all, and it matters to the court, and it matters to those that are watching this particular trial. Yes, there have been some times that these proceedings are acrimonious, or intense, and the court has had to chastise both sides for things that have occurred. I don't have any personal issue. Remember what I told you. I would tell the jury this when I charge them. The court has no interest in this case. My sole responsibility is to see that it is tried fairly as to both sides. So, and I maintain that in terms of I respect everybody in here as advocates, but I do need to have you just relook what you're saying to each other and to the court, because it really does make a difference in terms of our presentation before this jury, and then ultimately the jury is going to make a decision. So, look, all of you are very seasoned advocates. Even the newest lawyers in here have crossed that particular bridge at this point in time, given the length of time we've been in this courtroom. So I can just tell you from everybody's perspective, Ms. Love and everyone else, Mr. Adams and all of you in here, that you all have jobs you have to do. The court understands that. But please remember, at the end of the day, this won't be the last case you try with one another, and won't be the last issue that you try. So, but the court understands that you have a job to do, but understand that I have a job to do as well. I'm the referee. I have to determine what comes in and comes out in terms of my functions. So understand at the end of the day, we have that similar goal, but I understand you all have dissimilar objectives in terms of what the exigencies are in terms of your roles and responsibilities. But don't ever forget your duty of candor to the court, your duty of professionalism as advocates, and the duty of civility. It still applies in criminal cases as well. These defendants are presumed to be innocent, and they are innocent, and that's what this jury will ultimately decide. But We'll have to get there, and we'll make it, and they'll make a decision. Okay.
And Your Honor, I'm certain court means until proven otherwise, they are presumed innocent until
They're
proven
innocent right
otherwise.
now as we sit
Right.
here. So,
And-
and until I charge.
I stopped it because she just has to have the last word. She has to keep saying something, and he lets her do that. That's right. You got it, Tasha. So this has really been, it was really contrived, especially the way that they used the impeachment of a witness that they had on the stand. And what Mr. Steele kept telling the judge and the prosecution is when you impeach a witness, you could take that same tape and play it to the witness himself and impeach him. Instead, they brought in a detective, which some people say was a dirty detective, and she got out because she was about to be under investigation. I don't know if any of that's true or false, but she did retire, and she didn't say on disability 4 years ago. And I think she's just in her 50s. But it was something that happened with this case with the investigator that they had on the crime scene. There's something that was an internal affairs investigation, and they didn't have any of the report of the internal affairs investigation, they said. This is the only prosecution's office I know that can't get all the reports. They asked the lady to bring her reports when she come to testify on Monday. Well, she's retired now, so she can't get the reports. But the prosecutor should be able to get the reports. Or they should be able to get the reports under the Freedom of Information Act. It's some kind of way they should be able to get the reports that was reported. And she remembered all this stuff without her reports. She just looked at the videos that the prosecution has, and then she narrated the videos, and they were really opposed to her narrating because she wasn't there. But he allowed it. Regina said, of course the judge lets her have her way in his courtroom. Doesn't love work. Yes. Uh-huh. Yeah, you would think, though, with him being brigadier general for the military, and he is a judge for the military, and he may be just a judge for disability purposes. I don't know what type of judge he is, but he's the chief judge with the military, and he's a chief judge with this court. So I don't know why he should be so afraid of Willis, but I think it has to do with that case that he allowed that man to walk free when he thought he knew what he was talking about. And apparently he doesn't believe in checking laws. And the lady beat him on appeal. And that's what they said in the chat earlier, that Steele had beat him on appeal. And Steele had told him from the beginning he hoped they didn't have any issues from their past. But listen to some of the other people that are covering this case. They said that Steele is well liked and well known in Georgia for, his wins. And so this man, he kind of has a problem with that. And especially if Steele beat him on appeal. So I don't know, but he shows a real big bias to Steele, to Short, and Mr. Weinstein. Mr. Weinstein is on vacation, and he'll be back next week, I believe. But this judge, he really, I don't know. I want to say he's a good guy, but he makes it very obvious. Very obvious. And this woman, maybe they told her to tone it down because that little baby voice she's using is worse than that one when she's raging and hollering and screaming. But she never lets the judge sustain anything against her without her coming back, talking and talking and talking and talking. And before you know it, he's overruled it. I've never seen nothing like it in my life, and I watched a whole lot of court shows. I've never seen nothing like it. It's really sad. But that's what we had tonight. I want to cover the deception with Fani, with Miss Love, and on the campaign trail. So it's going to be interesting to find out, if any of these complaints that's been filed against Fani, if she's going to have any of these investigations. I saw a video that they were talking about her. They're disappointed in her because she refused to do debate with the candidates that's running for her office. She's decided to go to Florida. She's going to be on some panel with Roland Martin and a couple of other people. And it's something that they're doing. And Professor Nez was talking about how the flyer had drinks on it and all that kind of stuff. I thought that was funny. But the elections department said they were a little disappointed that she didn't want to come to the debate. And they're just going to have an empty podium there for her because the debate is going to go forward with the other two candidates. One is a Democrat and the other one is a Republican. And so they'll get to tell their story, I guess. But I think that if the people in Georgia would just start paying attention, because they're going down to the wire now. It's May 21st when they're going to have to vote in the primary. And so hopefully people are paying attention to the news or to their favorite blogger or whatever they look at. And hopefully they realize that it's something really wrong in Georgia. It's something really wrong. And hopefully they will, start investigating and read and do the right thing. Which it doesn't matter. It's like Regina said, it's this system that we have. It's everywhere. And we all know that's because it's humans everywhere. But it's even worse than that because it's humans that run a system that don't value all of its people. And so when you're not valued, you have to learn to value yourself. And in spite of, you have to just do what you need to do to get what you want done. And sometimes it just takes one voice. Sometimes it takes 1,000,000. But whatever it is, it starts with you. If there is a displeasure, you have to be the one to get it right within yourself. And then you can possibly, someone will see you do it. And then they'd want to do it too. Because really, it ain't nothing to it but to do it. Whatever it is. It's just like me and this technology. I hate technology so much. I have to really quit saying that, but I can't because I don't like it. Suge Avery, yep. And you know what? I believe she is a Suge Avery for real, though. Liquid been putting out some good videos where she talks about everything. Everything. A plethora of topics. And she keep you laughing. Keep you laughing. And there's some pretty good coverage on this case. I don't keep up with any of the other Donald Trump cases, but it's some things been happening in those cases And they all seem to be connected to the same thing. So, you know, you have to ask yourself, it's kind of just like I felt about us when I started on my journey. Who were we before we were slaves? How is it that the whole world hates us as a people? It has to be something to that. The entire world? Regina said, I hate to say this, but unfortunately, in speaking to people, when it comes down to politics and or political issues such as YSL trial, many lack information because they don't research or understand. Well, that's true, Regina. And we really don't research because a lot of us don't even have a clue about the mechanics of politics. We do everything out of our emotions as opposed to out of knowledge. And then when you try to give them a starting point, I ain't gonna read all that. Well, you're not going to know. You know, from kindergarten to 3rd grade, you learn how to read. And from the 4th grade on, you read to learn. So if you didn't get it by the 3rd grade, you're going to be left behind on a lot of things. Or you're going to take what people say for truth. And it doesn't necessarily have to be true. But we know that story, don't we? Let me just say thank you. And so as we get ready to close tonight, I'll do my favorite Whitney Houston. I believe the children really are our future. And then Regina said, where's the picture? Tell the truth and shame him now. Tell the truth. And I'll play my rendition of the OJs because that's what it's all about. And that's what the people only think about. Like, I think it was it Charlene who said it? Or was it Tasha? It was one of y'all. Said they talking about this is about people's lives, but all they really care about is the win. I like that one. That's right, Angela. Where's the video? If it ain't on video, it didn't happen. It ain't true. It's amazing. But here we had another great evening. I'm so glad you guys stayed with me. I am going to get ready to leave the Tiger's Den, and we'll hear our little money, and then we'll believe in our children. That's all we have. Oh, that was Tasha. Okay. Yeah, I like that statement. Money. Money. Some people will sell you out. Do you know what I'm talking about? Some people tell jokes of dirt. They don't care who feelings they hurt. I was told from times of old, the game's to be sold and not told. If you don't know what I'm talking about, hang around YouTube and you will find out about that mean Oh, mean, mean green, almighty dollar, cash money. Well, people don't let money, don't let money change you. Almighty dollar, cash money. People don't let money. Don't let money change you. Almighty dollar. They just keep on scamming and scamming everybody. Check them out, scamming and scamming everybody. I tell y'all, people don't let money, don't let money change you. Money, 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 money. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us who we used to be. Everybody's searching for a hero. People need someone to look up to. I never found anyone to fulfill my needs. A lonely place to be. So I learned to depend on me. I decided long ago never to walk in anyone's shadow. If I failed, if I succeed, at least I'll live as I believe. No matter what they take from me, they can't take away my dignity, because the greatest love of all is happening to me. I found the greatest love of all inside of me. The greatest love of all is easy to achieve. Learning to love yourself is the greatest love of all. And if by chance that special place that you've been dreaming of takes you to a lonely place, find yourself in love.